Good evening, everyone, and thank you for joining us for this important webinar in the Master in Electoral Policy and Administration series. For those who are new to the MEPA community, my name is Maribel Shirfan, and I'm the MEPA Program Coordinator. I'd like to also introduce the director of the program, Professor Lorenzo Gasbari, who's also with us today, and Cynthia Khoury, the LMS coordinator on UNITAR's side. Before we begin, I'd like to introduce to you a new initiative that we have at the MEPA this year called She Votes Africa, Empowering Leadership for Inclusive Elections. This is a new initiative funded by the Italian Ministry of Foreign Affairs and International Cooperation. I will send you guys the link in the chat box. This program is basically dedicated to empowering women across Africa, particularly those in marginalized areas, by enhancing their leadership roles in electoral processes. So this program is going to operate through scholarships to the MEPA program, through capacity building trainings, and the creation of a Pan-African network for collaboration and mentorship. Let's think about She Votes Africa as an initiative to advance female leadership and mentorship and promote inclusive elections. Moving on to today's session, I'd like to we are really thrilled to host a webinar titled Comparative Insights on Electoral Management Bodies Independence, a deep dive into South Africa, Zimbabwe, and Zambia, with our esteemed speaker, Patrick Kryticous. He is a former Chief Electoral Officer of Zambia. He is a MEPA alumni and a PhD candidate. Patrick brings extensive experience in policy analysis, project management, and international electoral observation. He will share his valuable insights into the challenges and opportunities faced by EMBs in these three countries. Without further ado, Patrick, thanks again for being with us. The floor is yours.
Thank you so much, Maribel. And good evening, everyone. Excited to be on this webinar. Allow me to just share my screen as we start. Great. I hope everyone can be able to see my screen.
Yes, great. Everything is fine.
Great, thank you. So as indicated, that's the study I'll be sharing with you. That's a comparative insights on electoral management bodies independence, a deep dive into South Africa, Zambia, and Zimbabwe. Already I've been introduced. That's my brief bio. Before I start, just allow me to also just acknowledge a few institutions and individuals. Of course, the UNITA team, the university, that's Santa Ana, and of course the Italian embassy in Zambia and the government of Italy, and specifically Ambassador Mario Antonino, who personally came to encourage me to join the MEPA program. And of course, not forgetting the scholarship that made it possible for me to undertake the exercise. My lead supervisor, Professor Lorenzo Gasbari, who's joined this webinar, who's here. And of course, the second supervisor, Dr. Melvis Indoloshe, and not forgetting Maribel Shirfan, who basically does everything and anything and was really, really helpful in making sure that both the team and everybody else that was on the program did what they needed to do. Thank you so much to everybody. Having said that, this is the outline of my presentation this evening. I'll start with basically the study motivation around what is it that motivated me to undertake this kind of study, the research questions that were asked to kind of answer the study, the research methodology, the conceptual framework, comparative analysis findings, conclusion, and recommendations. And of course, we'll end it up with discussions with everybody that is on the webinar this evening. So in terms of the study motivation, really, sorry, just a second. Yeah, thank you. Apologies for that. It was birthed from a point of view of realization, the important role that EMB independence does play. And having reviewed several literature, but also having been a practitioner in election management, you realize that independence of EMBs is extremely critical, firstly and foremost for ensuring that there are free and fair elections. Not just that, we have the term of credibility of those elections. But also you will note and also discover that once you review even the various models of EMBs that exist, one of the things that everybody strives to kind of attain is to ensure that there's transparent and biased electoral processes in whatever model that is being applied of an EMB when conducting electoral processes. So that element of transparency and unbiasedness in electoral processes is extremely critical. And you find that it is something, a trait that is usually associated with an independent EMB. And an independent EMB also kind of protects the decision-making processes, especially from external pressures. EMBs face enormous pressure, especially from external stakeholders, be it the executive and indeed all other interested parties that would want to influence the decisions of a particular EMB. So that kind of motivated me to get into this aspect. But in so doing, I was trying to look at the influence of governance structures as it relates to EMB independence, which has been underexplored. You find that there's a lot of literature, when you review the literature, there's a lot of literature that speaks to what should an EMB, an independent EMB look like, what are some of the parameters that you should be able to have, and so forth. But to be able to look at the link in terms of its influence as it pertains to the governance structure, the board itself, and its independence, the literature there is quite limited. And this motivated me to kind of undertake this exercise. So the focus was mainly to look at it from a comparative perspective, so that I could get an appreciation really of what is happening within the SADC region. And I picked constitutional democracies, and these are democracies that also have independent models of electoral management bodies. So this included South Africa, Zambia, and Zimbabwe. So the study really examines the correlation between board composition, appointment processes, and EMB independence, whilst offering insights for electoral reforms and best practices to strengthen electoral integrity. So at the center of it is trying to see what are the best practices that can be adopted within the SADC region, and later on also within the region and globally as practitioners of elections. And within that, you will note that the study's significance is basically identifying those factors that enhance or really undermine EMB. And this is within respective legal frameworks, but also attempts to kind of provide insights for improving electoral processes. And as I alluded to, strengthen democracy by making recommendations that will be able to foster trust in electoral systems. So in terms of the research question, the main research question was basically to what extent does the appointment process and indeed the composition of electoral management body governing boards influence the independence of EMBs in ensuring free and indeed impartial electoral processes. And this question was being answered by being guided by 6 additional sub-questions. First question is, what is the legal framework and the involvement of the legislature as well as the judiciary in EMB board appointments? Because who are the stakeholders that are involved basically in board appointments of the various EMBs within the 3 jurisdictions of the study? What is the extent of the executive influence in selecting EMB board members? What is the extent of public involvement or consultation in the appointment processes? What are the qualifications, expertise, and indeed diversity of the board members? What is the stability and turnover rate of board members? And lastly, what is the impact of existing legal framework on EMB's independence and credibility? So to answer those questions, the research methodology employed, like I earlier alluded to, a comparative case study approach, and it mainly kind of comprehensively analyzed the electoral management system and governing boards of the EMBs in the 3 countries. So this was a qualitative study. So qualitative methods were used to investigate the nature and appointment process of the EMB governing boards, and indeed their impact on EMB independence. This involved data collection as it pertains to document analysis, reviewing legal documents, constitutional provisions, electoral laws, and academic literature. So in terms of the actual analysis, legal frameworks did play a critical role, but in developing a literature review, in developing the conceptual framework, there was a lot of other document analysis, provision, academic literature, and so forth that the study kind of reviewed. The collected data was then subjected to qualitative analysis, and this was basically by identifying the themes. And in identifying the themes, I looked at what is it that an independent EMB model looks like as per best practice and as described in literature. What are some of those variables, and be able to assess the EMB against those variables as deemed best practice, aligned with those themes. So this is a conceptual framework of the study. Please take note right from the onset that when you're talking about EMB independence, there are various other factors that impact or influence the EMB independence. This study mainly focused on one particular variable, which is the appointment process. So when one talks about independence, there are factors such as budgetary autonomy, security of tenure, institutional design, operational environment, and indeed the electoral model and so forth. But also you can even take it further. You look at the stage of the country, both in terms of its development, whether it's a post-conflict country and things like that. And all those would kind of have an impact on how an EMB operates and the structure and so forth. So this study is very limited to appointment process because of the recognition of the importance that the members of the board have as it pertains to impartiality of managing electoral processes. So the conceptual framework looks at that. So it assumes that when you have an EMB, an independent EMB, what you're actually going to attain electoral integrity, the much needed electoral integrity to ensure that there's impartiality in the management and indeed conduct of the electoral processes in a country. So the appointment process is being looked at from a legal framework perspective, trying to understand EMB appointment procedures and how they comply with national legal requirements and indeed international obligations to be able to enhance the legitimacy of electoral processes. And there are 3 key variables that the appointment process, that underpins the appointment process based on literature and indeed best practice models. So you have independence and impartiality. And under independence and impartiality variable, you have 2 sub-variables, which is the appointment process, and you need the protection from arbitrary dismissal. And then you look at the expertise and competence of the composition of the board. And in this expertise and competence, you look at the qualifications for appointments. And then the stability and continuity, which is extremely important for an EMB. You need to have stability. You also need to have mechanisms for continuity. And in this breath, the variable that you look at is the issue to do with tenure of office and indeed its renewal. So getting into the actual comparative analysis, and this is basically a brief of each of those variables. Under independence and impartiality, the appointment process, you will see that all the 3 countries are well guided in their respective statutes. When it comes to South Africa, for instance, as it pertains to the appointment process, what you see it is that it is characterized by an independent panel. which includes high-ranking officials, such as the President of the Constitution Court. So this is the panel that is composed to be able to kind of facilitate for the nominations, including putting up public notifications, inviting for people to apply to be members. But it also has what one may term as parliamentary oversight, where you have proportional representation committee, which selects one candidate, and then National Assembly adopts a resolution, which then the president appoints. So there is a resolution from National Assembly of the individual that this is the individual, and then the president appoints based on that resolution. And key features, what you see from South Africa is that there is public interviews. There's also proportional representation. And based on this, what you get is a sense of high impartiality in terms of the constitution of the board. As it pertains to Zambia, the president nominates the candidates directly, as opposed to South Africa, where you have an independent panel. So in Zambia, you have a president who nominates the candidates directly, and there's no constitution of a committee or any other panel of the sort. It also has parliamentary oversight, but parliamentary oversight is limited to National Assembly ratification of the nomination. To note, the law stipulates that there is a clause for automatic confirmation of that provision. So appointment takes effect after 3 failed ratification attempts. So if the individuals that are presented before Parliament and third ratification, it fails, it becomes automatic. So what you see is that there's limited transparency, reduced checks, and indeed potential for executive dominance. In Zimbabwe, you also have the component of public nominations and interviews. They have a parliamentary oversight component, and they do constitute a committee on standing rules and orders, which oversees the process. The president selects the commissioners from a committee recommended list. So Zimbabwe also takes it a bit further and brings in that those checks and balances, as well as the oversight through that committee, which nominates that list. And the recommended list is the one that the president appoints from. So like South Africa, what you see in Zimbabwe is that there's also the public participation, but also limited presidential discretion. In terms of transparency, this is now doing a comparative between the 3 countries. Because when you're looking at the appointment process itself, you look at the transparency component, there are sufficient checks and balances, but also how impartial is the process. So South Africa and Zimbabwe utilizes public nominations, public interviews, and independent panels or parliamentary committees to kind of have those nominations. So this mechanism kind of enhances the transparency in terms of how individuals are brought onto the board. Zambia lacks similar mechanisms and concentrates power in the hands of the president. When it comes to checks and balances, again, South Africa and Zimbabwe, there is strong parliamentary involvement. There's also independent or parliamentary committees that recommend the candidates, as I indicated, which ensures that balance. Zambia does have parliamentary involvement as it pertains to the ratification. But there is a significant weakness in that. What you see is that the president's appointment, like I earlier alluded to, automatically takes effect after 3 failed ratifications. And this tends to reduce parliamentary oversight. So ultimately, the president choice is final. As it relates to impartiality, the mechanisms that are put in place, when you look at South Africa and Zimbabwe, involvement of independent bodies, committees, public participation, this now tends to foster some level of impartiality. Zambia, presidential nominations dominate the process. And of course, there's limited public or independent participation, which raises concerns over potential partisan influence. On the variable, again, of independence and impartiality, as it relates to the protection of arbitrary dismissal, So here you're looking at the actors that are involved in the dismissal, what are the grounds for the dismissal, and what are the checks on executive power, because you need to make sure that there are significant checks on executive power so that you don't have the arbitrary dismissals within an EMB. So again, all the three countries have these well stipulated within their respective legal frameworks, and the grounds tend to be similar, which is misconduct, incapacity, or incompetence, and this runs across the three jurisdictions. But you get to experience some significant differences when it comes to the process itself. If you look at South Africa, for instance, there is an investigative process which is initiated based on the Electoral Court recommendations. And this is the specialized court that is specialized in electoral matters in South Africa. And that's the one that initiates that. And then this is passed on to a parliamentary oversight where a National Assembly now takes that up, investigates and adopts adopts a resolution by majority vote. And this is quite significant. And only then the presidential action comes in. The president acts only with parliamentary consent. And this is quite very unique, and I hope that SADC region can learn something around this issue as it pertains to arbitrary dismissals. Preemptive suspension, it is allowed during investigation, but of course with parliamentary oversight. What the South Africa legal framework kind of demonstrates its robust checks by one, the Electoral Court, but also National Assembly. And this is what one may term as a good example of what a transparent and democratic process should be in reference to independence and impartiality, but protection from arbitrary dismissals. On the part of Zambia, however, the president also has the initiation power. So president initiates or responds to complaints. So the president can initiate on his own, but also can respond to a complaint. And this, there is a component of judicial oversight where the Chief Justice, because it's passed on to the Chief Justice, who establishes a 3-member tribunal to investigate this. So the tribunal would investigate the allegations and then provide those recommendations to the president. But what you also note is that there is preemptive suspension where the president can suspend before an investigation. And that's can be a weakness and can also be a center of concern. So what you see in Zambia is centralized executive power and, of course, limited safeguard against arbitrary dismissal. In Zimbabwe, the initiation, the president refers any case to the Chief Justice, and the tribunal, like Zambia, similar situation like Zambia, you'll have the Chief Justice who appoints a 3-member tribunal of legal experts. But the difference, the significant difference with Zimbabwe is that the tribunal is well guided by the Commissions of Inquiry Act, which stipulates how this should be done. So the preemptive suspension is also allowed. The president can do that, but tied to tribunal investigation and in line and guided through the Commissions of Inquiries Act. So it has the strength in that the comprehensive and legal aspect, especially as it pertains to the Commissions of Inquiry, provides that safeguard against overreach on the part of the executive. I think I've already spoken to this as I was making that presentation. So this is basically what I was highlighting to in terms of the strengths of the different aspects of the various countries as it pertains to arbitrary dismissals. So now coming to the other variable as it pertains to expertise and competence, qualifications for appointment, similar as well. This one, all the 3 countries, they are guided by law. It's stipulated. When it comes to South Africa, you will see that 3 key parameters dominate that, which is basically being a citizen of South Africa, must not hold a prominent political profile at the time of nomination, but significant to note is one member must be a judge. So within that, within the South African law, what you see is that the focus ensures independence and neutrality, but there's also emphasis of judicial expertise for legal oversight. Zambia is a little bit more detailed when it comes to requirements. It kind of prescribes more than the three jurisdictions. Of course, Zambian citizen, permanent residency, and it also goes further to look at one's criminal record, and also prescribes educational qualifications, minimum school certificate and degree, and the professionals are also highlighted, including electoral administration, finance, governance, public administration, and law. So in the case of Zambia, it's much broader. The framework is broader, mainly emphasizing the technical competency and integrity. So it doesn't kind of lean towards, for example, judicial expertise, like is the case in South Africa, and as you will note, in Zimbabwe as well. So Zimbabwe, similar aspect, citizenship in terms of requirements, but you will note that for Zimbabwe, there must be, the chairperson must be a sitting or retired judge or eligible for judicial appointment. Whilst other members, again, it's basically just competencies in public management or private affairs and demonstrated personal integrity. So South Africa and Zimbabwe are quite similar in terms of their emphasis on judicial leadership for oversight. And this is basically a summary of that. Another variable is the issue to do with stability and continuity, which is extremely important. Stability and continuity, when you're talking about EMB independence, is important because without stability and continuity, it creates, of course, directly instability and even institutional memory, but it also makes members vulnerable to external influence. And so across the three jurisdictions, they have significantly long tenures. South Africa, Zambia, with the same tenure, which is about 7 years fixed term, Zimbabwe, 6 years. And these are relatively good tenures because they overlap the electoral cycle, their respective electoral cycles, which is 5 years. Where you see most discrepancies is around the issues to do with the reappointments. If you look at South Africa, the reappointment requires National Assembly recommendation. This ensures parliamentary oversight and indeed accountability. Terms are limited to 2, but it prevents power concentration and also promotes new perspective, as this has to go through National Assembly in terms of the reappointment process. As it relates to Zambia, however, this is at the discretion of the president. Lacks direct parliamentary involvement at this particular point in time, reappointments allowing for potential executive influence. So term limits, you will have a maximum of 2 terms, and of course limits a prolonged individual influence within the commission. As it pertains to Zimbabwe, similar to South Africa, reappointments require parliamentary committee recommendation. But for Zimbabwe, there's also a unique component, must repeat full appointment process. And when you look at the analysis in terms of the reappointment process, term of length, like I indicated, this is quite good. And for all the 3 jurisdictions, this is quite sound, but on the reappointment process, South Africa and Zimbabwe, the involvement of parliamentary oversight ensures checks and balances. In Zambia, this is executive discretion, which introduces potential for influence. So on the part of transparency, because of the involvement of the parliamentary oversight, Zimbabwe tends to lead, because what you see is that the procedures for reappointment apply as though it was first appointment, and this is for all members. South Africa, this also applies as it relates to the chairperson. Zambia has no transparency mechanism as it relates to the reappointment because it's at the discretion of the president. So as I conclude, what you note really is that looking at these three jurisdictions and based on the parameters of the study, appointments, dismissal, qualifications, and indeed tenure of commissions, you see that each jurisdiction, of course, you'll have each EMB playing a critical role in determining the independence and indeed the transparency of the electoral processes. But as it pertains to the comparison between the three countries, South Africa and Zimbabwe have developed more robust systems with judicial and parliamentary oversight. And this is important as it relates to limiting executive discretion and indeed enhancing the impartiality of their respective EMBs. In contrast, Zambia's legal framework, while structured, permits greater presidential influence, particularly in the automatic ratification of appointments and discretion in renewal, as well as dismissals. And this could potentially compromise the independence of the EMB. The study basically concludes that while the three countries emphasize non-partisanship, as well as limit commissioners to 2 terms, Zambia, on the three comparative basis, requires significant reforms to enhance the transparency and independence component of the appointment procedures. This is to its EMB. The recommendations, of course, would include the inclusion of public participation in the appointment processes, establishing independent oversight panels, revising the automatic appointment provisions, strengthening both judicial and parliamentary oversight mechanisms in the appointment processes. These reforms would and are essential, especially when you're looking at an EMB model from a constitutional based country in terms of an EMB which is independent model in ensuring the integrity of electoral processes in the region. But I must also mention that despite these insights, there are several gaps that remain, which of course would require further study. So future research could explore the impact of these governance differences in actual electoral outcomes and public trust in the electoral process. So this is as prescribed in law, but practice is another thing. And you will note, if you're an electoral practitioner, that there are 2 distinct factors. You just don't look at law, you also have to look at practice. So we might be saying, for instance, that the Zambia's legal framework is lacking, but in practice, you might find that the way it is being done could even be stronger than some jurisdiction that seemingly look like they have stronger legal frameworks. Probably what is in law is not being respected and so forth. So it would be important to do further study now to correlate and explore the impact of these governance differences as it pertains to actual electoral outcomes and public trust in the electoral process. Thank you so much, and I'll be happy to discuss.
Thank you so much, Patrick. It was really such an interesting presentation. So we're opening the floor now for questions. Please, whoever has a question, you can just raise your hand and we can open your microphone. So we have George. You should be able to talk right now. You just need to unmute your microphone.
Good evening, everyone. Am I audible?
Yes.
You are. Good evening.
Yes. Good evening, Mr. Nshindan.
Good evening.
Thank you. Yeah, thank you so much for the wonderful research you are undertaking. It's very progressive and has potential to change policy as it relates to the electoral system in Zambia. Based on the findings and recommendations, I would just like to draw you back to the qualifications of the board chairperson for the Electoral Management Board. I don't think, I'm not so sure if I didn't get you clearly, but according to the constitution of Zambia, for a person to be, the chairperson of the Electoral Commission, one of the qualifications is that they should have been a judge of the Superior Court. I didn't hear you mention that. I don't know if I missed you due to network, but I didn't hear you mention that. I don't know what could be the issue. Is it that it has changed or what? I would just like you to clarify on that one. Thank you.
Thank you. Can I proceed? Is there any other? Okay,
Yes.
I could answer while we're waiting for any
If
other.
you want, I was
Yeah.
thinking we could take on one more question and you can answer both of them directly. That gives you a bit of time also to ponder on them. Would that be okay?
Yeah, sure.
Okay, so taking on one additional question, we have Poland. You have the floor, Poland. Go ahead. You just need to unmute your microphone.
Good evening, everyone.
Good evening,
Good evening.
Poland.
So yeah, my question tend to goes both ways. So I just want to understand a little, because I've seen you showing us the each countries on how the member of the body of electoral management system they are elected. These are so that in South Africa, I can't appreciate what's happening in South Africa, how they proceed and how to nominate the electoral management body compared to the Zambia and Zimbabwe. Because compared to my country, for example, when the president nominates the electoral management body, do you think that in the election process, there will be a transparency? Because the person who's nominated will somehow think that he probably need to protect whatever who has nominated the position. I do see also a conflict on that as well, because when the election doesn't go well, it tends to bring a lot of conflict in the country. There is civil war and all of that. So you as an expert, what is the best system that you think it's better for a developed country, for example? Thank you so much.
Thank you.
Thank you for your question, Pauline. So Patrick, you have these two questions. Where is yours?
Right. Yeah, very good question. Thanks, colleagues, for those questions. I'll start with my colleague from Zambia. The law was amended. Before, yes, there was a requirement that the chairperson should be a retired judge or a legal practitioner, but that is not the case anymore. So it's basically now focused on those parameters. It just prescribes the qualifications and the fields of expertise. So it's more to do with the technical aspects of it as opposed to that. So Zambia is the only country between the three jurisdictions that does not emphasize the judicial component as it pertains to the chairperson, including the composition. Because when you look at South Africa, it doesn't say the chairperson should be a judge, but it emphasizes that one of the members within the commission should be a judge, or should have been or qualified to be a judge. Whilst Zimbabwe, it's very categorical. It states that this is one that should have been a retired judge or one who's qualified to be a judge, to be a chairperson. For Zambia, this was amended. If you look at the Electoral Commission of Zambia Act of 2019, that was amended, and the qualification is open. So you can have anybody within the stipulated qualifications to be a chairperson. You don't have to be a legal expert. The other question, as it pertains to the best model for countries, and of course the conflict that arises with appointments, and allow me to just share back my screen, just to kind of pinpoint the point I'm trying to highlight. Okay, I hope it's visible. Yeah, so which is the best model? I think South Africa tends to do a very good job. You talk about the president having to put forward a nominee, and if somebody goes against that nominee, it has consequences, of course, repercussions from the executive side of things, and so forth. But South Africa tends to shield that because the nominations do not come from the president. An independent panel is constituted, and they even put out an advert. So they'll put out a public notice inviting people. And when you look at the composition of the panel, it's a high-ranking panel, including, for example, the president of the Constitutional Court, who sits there and come up with a list of who should be member, or not who should be, basically receiving the applications. And once those applications are received, they're also further passed on for parliamentary oversight. So proportional representation again applies, where they select the candidates and the National Assembly adopts by a resolution. And then after the adoption, it's only when the president appoints. So the president is coming in at the tail end of things. And he basically has very little say or control of who comes to the EMB. And I think this is something, even when I was presenting, we could learn from our colleagues from South Africa of how this can best be done. There's a component of public participation, but what you get also is an independent panel which scrutinizes the applications. After the independent panel, this is further passed on to parliamentary oversight, where you have the legislature coming in to be able to now look at the selection. And now, based on the candidates that they're able to adopt a resolution through a proportional representation. And only then is that passed on for president appointment. So I think, in my view, in my perspective, this demonstrates as one of the best models for appointments of members to the commission.
Thank you.
Thank you very much for these answers. So I have two questions also in the chat box. I'm gonna read them. So one question is from Amon. My question is about the electoral systems between Zambia and South Africa. What impact does the two countries' electoral systems have on party systems in the two countries? And the second question by Simone is a very insightful study. RSA seems to have the more exemplary EMB, independence, protections, and mechanisms. The legitimacy and adherence to the rule of law by the government in power determines integrity and independence of the EMB. So it's a comment. I'm trying to see if we have another. Okay, we have another question that we just received from Olumide. So I'm curious about the automatic confirmation provision in the case of Zambia. If appointment takes effect even when a nominee fails the ratification process, then what's the legal usefulness of the ratification process? Has there been any attempts to reform the ratification process? Thank you, Olumide, for this question.
Great. So basically, there are two questions. The other one was a comment. So as it pertains to the electoral systems, in reference to the EMB, there's really little impact or difference as it would affect the entire electoral process. Each country will develop its own electoral system based on their uniqueness. And this is not unique or something extraordinary. So you'll have every jurisdiction that looks at its environment, operating environment, what is the most suitable electoral system to be able to adopt. But within the management of that electoral system, there is what we are now talking about, the electoral management body that ensures that it administers that electoral management system effectively and in an impartial manner. And this is now where the comparison comes in. How robust or how effective is that body which is there, and how is it shielded from external influence? Is it able to undertake its mandate as prescribed in law effectively without any undue influence? And those are the questions that the study was basically looking at, trying to make that comparison, not necessarily the electoral system that is at play, in the country. So that factor is very, very important. So it doesn't matter what electoral system you're applying in your jurisdiction, but how does that body which is managing that electoral system, how is it structured? And when you look at South Africa, Zambia, and Zimbabwe, these are constitutional democracies. And within the constitutional democracies, they've also prescribed that they shall have an independent EMB. And an independent EMB, based on literature, you will see the parameters that are set. Those are the variables that we're using to be able to assess, not necessarily around the pertaining electoral system. So that, of course, will be something else where you, if you want to go further, whether the electoral system would have an impact or not. But as it pertains to undertaking the mandate, you're basically looking at it from that perspective. The automatic ratification in Zambia, yes, like I said in my presentation, it really waters down the legal framework. One would basically say, then the ratification process is simply rubber stamping, because on third ratification, if it doesn't go through, it becomes automatic. So the president yields significant power such that whoever he or she nominates, it is a given that they will be there, even if Parliament decides not to. At third point of ratification, if it fails, it becomes automatic. And this is a significant gap. I don't know what the thinking of the legislators were, but as it pertains to the independence and principles that guide EMB independence, that is a major weakness, and it requires reform. Has there been any efforts to reform this? To the best of my knowledge, I've not seen any as it relates to this. I hope that this is something that will be taken on board moving forward, but of course not now, because we will be heading into elections in 2026, and undertaking electoral reforms before close to an election is not deemed as good practice in electoral management. So we hope that immediately as the new electoral cycle resumes, these are some of the parameters that could be looked at.
And we have a hand up. Ms. Daraini, you just need to unmute your microphone. Nice to have you with us, and congratulations on your new promotion. Ms. Daraini is also a MEPA alumni and a valedictorian as well. Go ahead, Ms. Daraini.
Hello, can you hear me? Good evening.
Yes, we can hear you.
I have like two questions. The first question, I would like to know if truly the South African EMB is truly independent financially, or the funding of the commission. So I'd like to know if the government, if the funding has to go through the executive and the legislature before they can get, if truly they have to get the funding for the running of the EMB, I doubt it if they are going to be truly independent. And my second question is, like for the members of the EMB, if one is found wanting for any of corruption or any other thing that is an offense, do they take them out? Is it that, how do they really, how do they manage it? Or it has never happened in South Africa? Thank you.
Since you have two questions right now, maybe let's take on the other questions after that.
Okay.
Okay, great. The study, as I alluded to, was primarily focused on appointment processes. And I did allude to the fact that, yes, when you're looking at EMB independence, there are other factors that come to play, including issues to do with financial independence, the operating environment, and so forth, and so forth. So the study was very limited to appointment process. But one thing I do know, of course, through review, is that when it comes to financial autonomy between the three jurisdictions, South Africa is better in terms of its setup. And it's better in the sense that once an appropriation has been done, that the funding for the EMB is given at once to the EMB from the Treasury. And the EMB manages the funding as a whole, which is not the case for the case of Zambia and Zimbabwe. Zambia has to produce funding profiles every so often on a quarterly basis or so, and it's at the discretion of their respective treasury. Both this is Zimbabwe and Zambia, which is different from South Africa. So South Africa enjoys even better autonomy as it pertains to the financial independence. But again, like I said, this study was limited to appointment processes, how members get to the board, and how they are reappointed to the board, and of course, the variables that relate to that. The second question had to do with how the offences are dealt with in South Africa, and whether there have been any instances of dismissal. I would not speak to the instances specifically because I didn't go that far. I basically looked at the existing mechanisms as it pertains to arbitrary dismissals. Let me just get to. I'm trying to see if let me share again so that I can just make that point clearer. So you will see in the case of South Africa again, is that they do go a step further in comparison, for example, to Zambia. Zimbabwe has a slightly stronger mechanism in comparison to Zambia, but South Africa's is a little bit more robust. Firstly, the investigation process, if there's suspicion of misconduct, it has a component of investigate, which is initiated based on the electoral court recommendations. And you see that South Africa as a jurisdiction, it has a specialized court, which just looks at matters to do with electoral processes. And that significantly enhances its capacity, judicial capacity, to look at electoral matters. And based on that recommendation, then it's further passed on to legislative oversight through Parliament, where National Assembly now investigates and adopts a resolution by majority vote. And only then does the president act based on that parliamentary consent. And of course, you see in other jurisdictions, for example, like Zambia, where the president can suspend just on mere suspicion preemptively, and you're suspended before even investigations are done. But in the case of South Africa, because this process would have started with the recommendation of the electoral court, it's only allowed during investigations at that particular point in time. So it has quite a strong and robust mechanism as it pertains to arbitrary dismissal. And it's one of those cases we could be looking at. And it's quite impressive because when you look at South Africa as a constitutional democracy, it is an infant in the SADC region, but they've done quite a lot to be able to enhance their legislative framework.
Thank you, Patrick. We have two more questions that we're going to have time to take on, two more questions. Unfortunately, thank you so much for the interest. I can see a lot of other questions. Maybe we will have the pleasure of hosting Patrick again for another session. So we have a question from Ms. Gonzalez. Can you please talk about lessons learned about the most effective ways to achieve reforms aimed at improving the independence of the MBs? And we're going to take on one more question from the public. So we have Ali. I'm allowing you to talk, so you just need to unmute your microphone.
Thank you very much. Can you hear me?
Yeah.
Yeah, thank you very much. I really appreciate the presentation. Although I came in a bit late, but I was able to catch up and understand the presentation. And basically, I appreciate that when you look at the independence from the perspective of appointment, you're able to gauge out a lot of things. But I think that the starting point should have been the legal framework. Legal framework actually is the basis upon which even appointments are based. And when you look about operational autonomy, financial independence, appointment, all are based on the legal framework. But unfortunately, in practice, what happens and the framework does not actually reflect on the actual practice. And as you look at the three countries, you might think that Zimbabwe and South Africa are a bit strong in terms of their independence, in terms of the appointment. But I wanted to comment on the issue of while Zimbabwe, for example, while legally independent, has faced significant challenge in terms of trust and public trust in the institution, and how the EMB was conducting elections. So how do you relate the good legal foundation and strong legal foundation and the actual practice regarding the independence of institutions and, by extension, public trust in those institutions? Thank you.
Thank you so much. I did speak to this during my presentation. Let me start with the last question. And you are definitely on point. And this is something I highlighted as one of the gaps of the study that we'll be able to look at. If you look at my conclusion, I talk about this despite these several insights. And I must mention that the study focused on the legal framework to look at what is the legal framework, how does it promote EMB independence? But legal framework, what is in law and what is in practice are usually very different, and the two need to be well understood. So one of the things that could be looked at, like you're citing the case of Zimbabwe, is to be able to explore the impact of these governance differences in actual electoral outcomes. And indeed, what you mentioned, public trust in the electoral process. So is there a correlation between what the legal framework is saying and in practice what is happening? The results might be different. As you have cited, I would not validate that point because I haven't researched it enough to say that is the case for Zimbabwe. But like you have indicated that, for instance, Zimbabwe would have a significantly stronger legal framework than Zambia, but the perception is lower as it pertains to public trust, and there is what is perceived as not so credible electoral outcomes. Again, this is something that requires now a further study, and those that would be interested to kind of look at this in depth, this is an area now where you interrogate between law as well as practice. And it's a very valid point that you raise, and literature really emphasize on this component of legal framework versus practice. And it's not just unique to even Zimbabwe. If you look at Zambia, there's a lot of things that are in legislation but in contradictory when it comes to practice. And I believe the same can be said about South Africa and many other jurisdictions. So it's a very critical component. So what we need to, as practitioners, aim for, ensure that the legal framework really is implemented and is reflective of what is being practiced. And there are mechanisms to be able to hold, to check and account those that abrogate the existing legal framework. And coming, of course, to the other questions, lessons learned to be able to achieve reforms, to improve EMB independence. I think first and foremost is a willingness and an open process. Willingness, firstly, on the key stakeholders who would be in the executive. Unfortunately, what you see in most of our jurisdictions, there is a tendency and appetite to be able to hold on to power by our leaders. And if all the reforms that you see around issues to do with electoral reforms are tailored to preservation of power. I think we need to go beyond that aspect to see how do we improve our governance institutions, including the EMB, and be able to remove some of these biases and conduct processes that are transparent and robust enough to be reflective of that. Timings of these reforms are extremely important. You see a lot of the jurisdictions. I've been privileged to be on a number of observation missions. You find that there's a tendency to do electoral reforms close to any elections. And there's a lot of misgivings towards that, but it's also deemed as not good practice to be able to do that. The best time to do reforms is immediately after an elections. You do a post-mortem of the elections, post-election review, or how were the elections conducted, what are the issues that came out, and of course through a consultative process that is inclusive, look at the reforms that are required, and you're able to carry the citizens and indeed various stakeholders with various interests together and come up with a robust agreement of what needs to be reformed, such that as you are getting to the electoral year proper, as those would have already been implemented, and they're not seen as reforms that are driven by the executive to be able to perpetuate their stay in power. They could actually be very positive reforms, but they undermine the credibility of the EMB because of the timing that these reforms are being done. The EMB tends to become a complice even when they are not, because of course elections are competitive in nature and various stakeholders who have various perceptions of what is going on. So it's important that these are done with stakeholder consensus and making sure that they're as consultative as possible.
Thank you so much, Patrick. Thank you for this captivating presentation and really for this interesting webinar. We'd like to also thank all the participants who have been with us through this ride. I did want to remind you all that I saw a lot of interest in contacting Patrick. For those who have follow-up questions, feel free to email us and we will put you in contact with Mr. Patrick. And for those that are interested in future webinars that have to do with the initiative of the She Votes Africa that we spoke about, I sent out the link in the chat box, and you have the email of the MEPA program. Feel free to reach out to us. When you click on the link, you will see information about the initiative and a form to fill, whether you're interested in scholarships or in attending webinars or just being a part of the network. Feel free to fill the form. It's 12 questions, so it would be normally it should be quick. So thank you again for being with us, and I wish you all a very nice evening. Thank you again, Mr. Patrick, as well.
Thank you so much. Thank you, everybody. And really honored to have been on this webinar and really enjoyed the discussion. Thank you so much.
Thank you, everyone. Especially Patrick. It was a brilliant webinar.
Thank you.
Really enjoyed it. Thank you.
Thank you, everyone. Thank
Have a
you.
nice evening, everyone. Bye.
Bye.